Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
The Commissioner of Income Tax by order confirmed the addition on account of short-term capital gains and held that there is a clear distribution of assets as partners have also withdrawn amounts from the capital account stop. CITA also observed that value of the assets of the firm, which commonly belonged to all the partners of the partnership, have been irrevocably transferred in their profit sharing ratio to each partner stop. To the extent that the value has been assigned to each other, the partnership has effectively relinquished its interest in the assets, and such relinquishment can only be termed as transfer by relinquishment stop. Therefore, according to the conditions of section 45 are satisfied, and therefore the assets, to the extent of their value distributed, would be deemed as income by capital gains in the hands of the assessee firm stop. The CIT also observed that the transfer of the revalued assets had taken place during the previous year, and therefore the liability to capital gains arises stop. The relied upon the decision of the Bombay High Court in the case of Commissioner of Income Tax Associates and distinguished the decision of the Bombay High Court in the case of Commissioner of Income Tax stop. In an appeal preferred by the assessee, the by judgment and order, and relying upon the decision of this court in the case of Commissioner of Income Tax West Bengal versus Hind Construction, allowed the appeal and has set aside the addition made by the AO towards short-term capital gains by observing that, as observed and held by this court in the aforesaid decision, revaluation of the assets and crediting to partners account did not involve any transfer stop. The ITAT observed and held that the decision of the Bombay High Court in the case of associates and others supra shall not be applicable, and held that the decision of the Bombay High Court in the case of shall be appealable stop. Relying upon the decision of this court in the case of Hind Construction Limited supra, by the impugned judgment and order, the High Court has dismissed the appeals preferred by the revenue stop. Hence, the present appeals, being Civil Appeal number 8258 of 2022 stop. Shri Rupesh Kumar, Learned Counsel, appearing on behalf of the revenue has vehemently submitted that in the facts and circumstances of the case and in law, both the ITAT as well as the High Court have seriously erred in deleting the additions made by the AO towards short-term capital gain stop. It is vehemently submitted that in the present case, as the assets of the firm were revalued to increase the value by an amount was credited to the accounts of the partners in their profit sharing business, and this case was filed in the High Court in above mentioned civil appeal stop.